Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. As the title of this video suggests, we're discussing the doctrine of consular non-reviewability or consular absolutism and what's called plenary power in the context of U.S. visas and immigration. Now, we've made a number of videos on this channel, mostly dealing with what are called U.S. tourist visas, B1, B2 visas, and other non-immigrant visas, talking about the doctrine of consular non-reviewability. When I deal with immigration, that's mostly where I see it. In fact, I never see much of this. Well, to some extent, I see it operate in the immigrant visa categories, but not to the level you see it with non-immigrant visas. That being said, it seems like the doctrine of consular non-reviewability has started to kind of go off track quite a bit, and there's some of my colleagues out here who think it's kind of a runaway train, depending on the jurisdiction you're talking about. But one thing I've always really liked about the U.S. Embassy here in Bangkok is they seem to have kind of taken the position that, look, doctrine of consular non-reviewability, we got a lot of unfettered discretion on the non-immigrant side, because that's a different side of the Immigration Nationality Act. Whereas on the immigrant side, especially in a family context, spousal visas, fiancé visas, even parent-child visas, those kinds of things, family-based visas, the view has always been, look, the doctrine of consular non-reviewability doesn't have a lot of applicability there because there are specific laws. There's a legal framework to deal with things like a U.S. marriage visa. And you need to deal with that legal framework. There's no real discretion. You got to deal with the law. Now, interpreting the law and making your own factual determinations, that may kind of fall under the doctrine of consular non-reviewability, but in a number of jurisdictions, and I want to be clear on this, and this is not me, showing any favoritism to Thailand. This is just how it is based on the comparisons I've seen in dealing with other jurisdictions, and more to the point, albeit anecdotally, talking with other colleagues in other jurisdictions. Other places use the doctrine of consular non-reviewability, quite honestly, in my opinion, improperly, because, again, there's a legal framework in the Immigration Nationality Act that deals with family-based visas. Sort of as a result of this, there have been a number of cases that have been going up through the U.S. court system which have been discussing the doctrine of consular non-reviewability, and it's looking like possibly in a future case you might see a court decision come down and maybe not necessarily shatter that doctrine, but maybe change it fundamentally. And the reason this could happen is it all emanates from what's called the plenary power, which you got to remember, plenary power is a different thing from legal authority. Plenary powers are much more amorphous and they're much more absolute. And the thinking is, for example, the executive of the United States, being the president, has a certain amount of plenary power when it comes to that person and anyone he appoints. For example, the head of the Department of Homeland Security or the Department of State or any of the consular officials who are posted abroad. The long story short, what I'm trying to get to is that authority can sort of be delegated downward because it's deemed that the executive has the power to make determinations about who, in terms of foreigners, can enter and exit the United States. And quite honestly, I agree with that notion. I'm actually kind of a believer in plenary power because I think that's exactly what it is. It is a plenary power vested in the executive to make determinations about what foreign entities can enter the United States and what foreign entities cannot. Now, it's not unfettered, but they have sort of pocket authority, if you will, to just deal with this stuff. That's what they're elected for in many ways, and that's what their subordinates are delegated to do. But again, we're starting to see cases that are starting to challenge this, and I think we're going to see some major changes in this over the coming probably 2 or 3 years. I'll certainly keep folks updated on this channel as the situation evolves.